Ladies and gentlemen, and welcome back to another What If video. My name is Viep here, and as always, it is great to have you. Today's topic is what if load shedding takes place during working hours? Must employees be paid? We know, unfortunately, that it's just a matter of time before we experience load shedding again. The question is, if load shedding takes place during working hours, can employees insist on payment of their full salaries or wages if their working hours have been reduced as a result of load shedding? As the employer is not at fault, one might think that the employer should be able to reduce the employee's pay in proportion to the reduced working hours. But this is no simple matter. According to our law of contracts, a party can be relieved of its duty to perform if performance becomes impossible due to circumstances beyond its control. The argument is, therefore, that in the case of load shedding, it is impossible to perform in terms of the contract, and this impossibility of performance is beyond the control of the employer. However, it would seem that in most instances, the principle of impossibility of performance has different implications in the employment relationship. The question is, what is this difference? Now, in the case of a contract of employment, the employer's obligation to pay is generally not dependent on any work actually being performed. Instead, the normal rule is that the employer's obligation to pay arises once the employee has made his or her services available to the employer. In other words, reporting for a duty. The employer therefore has an obligation to pay even if the employee's service or services cannot be utilized due to circumstances beyond the employer's control, such as load shedding. We should also take note of the fairly new provision in the Basic Conditions of Employment Act, more specifically Section 9 capital A, that states a worker who works for less than 4 hours a day must be paid for 4 hours work on that specific day. If the nature of the contract is such that the employee is not paid for making his or her or their services available to the employer, but rather to complete a particular job, then the employer's obligation to pay would only arise or arises only once that job has actually been completed. Similarly, if the employee is appointed on what we call an as and when the need arises basis, then the employer will only have an obligation to pay if the impediment to the utilization of the employee's services arises during a specific period that the parties have already agreed upon that the services would be required. So what can the employer do in the case of normal employment? Normal employment as we know it. In order to override the normal rule, an employer can enter into an agreement with its employees or the unions that the obligation of both parties be suspended for any period that performance becomes impossible due to circumstances beyond the control of both parties. If the employees or their unions refuse to agree, then there are two possible options. Option one is the employer can declare a dispute that can eventually lead to a lockout in order to compel the employees or the unions to agree. Alternatively, or option two is if the continuation of load shedding poses an operational threat to the employer, then the employer could embark on a retrenchment process in respect of those employees who refuse to agree. However, neither option, option one or option two, will provide immediate relief and are costly and time consuming. As we know, in all retrenchment cases, before one can dismiss, one needs to consider alternatives, try and accommodate the employees. And in the case of load shedding, one of the questions would be what measures did the employer consider? And for example, why was a generator not purchased to ensure that the lights stay on? In some industries, there are bargaining council agreements that deal with impossibility temporary layoffs, also sometimes referred to as short time. And in this case, such a provision would prevail over the normal rule that we've discussed or any contrary agreement between the employer and the employees. Changes to these or such a provision can only take place, obviously, at bargaining council level. Ladies and gentlemen, that then brings us to the end of this video. Thank you for watching. As always, for all your labor-related queries, please do not hesitate to contact us. Until next time, bye-bye.